Hey, it's Justin Harvey. Thanks for tuning in to the Anesthesia and Pain Management Success podcast. With APM Success, we take a close look at important topics pertaining to business, practice management, personal finance, and careers for anesthesiologists and pain management physicians. We work hard to take your critical questions straight to the experts. Thanks for listening. Hello and welcome to another episode of Anesthesia and Pain Management Success. We're going to have some content specific to a very important area of financial planning today, and that is estate planning. And I'm really excited to have attorney Tammi Caress here joining us. Tammi runs an estate planning law firm here in the Pacific Northwest. I am in Portland, and she's my neighbor here, and I'm excited to have her lend her expertise and perspective to our show. Tammi, welcome.
Thank you. I'm happy to be here.
So this is one of those areas, and I guarantee you, like, if I was talking to a bunch of financial advisors, everyone would be like, "Oh yeah, it's estate planning. It's like one of the hardest things to get people to do. It's having someone sit in life insurance is right up there with it. Like, sit down and soberly consider the impact of your death for more than a few minutes, and then do planning around that. It's not something a lot of people are just like eager to dive into. So what brought you into sort of this corner of the legal world, and what kind of experiences have you had in this department?
Oh my gosh. Personal experiences?
Yeah.
Okay. So I've had more than I'd like to admit. Not admit, but it's funny because when I think about when I went into law school, I kind of thought about doing this area of law, and it was more in the back of my mind, and it kind of just really went into the front of my mind when I went into law school. And I was very fortunate to have a professor who saw something in me and really helped and encouraged me to, whoops, that was my kitten, um, to help and encourage me to go on this route. And then when I think back as to why, I unfortunately had lots of loss in my childhood. My father died when I was really young. I saw how my mom had to manage that. And, it's a lot for the family. It's a lot on the children. It's a lot on a surviving spouse. And for some reason, I just kind of gravitated toward this area of practice, and I kind of geek out on it. I like reading the intricate details of the documents. I like figuring out the tax issues, so that's kind of, I guess, where I, um, you know, just gravitated towards this because I had the right people in my life who saw something that said, no, this is something that you are good at and you should do. So,
When
yeah.
you're starting the planning process with someone and you're
Yeah.
explaining to them, okay, here's how it's going to work. Here's what I need from you. Here are some of the important conversations, if you're married, you and your spouse need to have. And you can see that look on their face as you're describing it, that it's sort of like being shuffled lower and lower on their priority list. You probably know the look I'm talking about because I see this with
Yeah,
my clients.
sure.
What do you share in that moment? What is this I'm looking for myself. Like, what is the cheat code to get people to get this done? Because it is important, but it's difficult. It's emotionally laborious, and it's not a mystery that it's is that way.
Everyone is so different. I have clients that are just very on it and they want to get it done. I have other ones that are just super nervous when they walk into my office. Fortunately for me, when they're coming into my office, they've already kind of committed to, okay, I need to do something. But what I find with them getting to my office, it's usually because they have experienced a health crisis, and now they're like, oh my gosh, I need to do this. Or they've witnessed the death of maybe a parent or a grandparent or another family member, and they can see how hard it is on the family because there was no plan in place. And usually when there's some life, so what I see a lot of times is younger folks will get their plan done when they start having kids, but then they'll put it on the shelf for 20, 25 years. And then, family scenario occurs, and then that makes them think, oh my gosh, I probably need to do this. So It's, really hard for people to think about and plan for the death if they haven't experienced it, frankly. I mean, I really find people come to me when they have out from outside sources look, through the looking glass and said, "Oh my gosh, they're having a really hard time. I want to make sure I don't do that to my family." So that's usually when they come to me, but it is challenging. Especially when I have couples. I do have some couples where maybe one will say we need to get this done, and the other one they're kind of like just really pulling their spouse along because the spouse just not want to think about it. It's hard. It's really hard, and I think you probably have more of the heavy lift than I do because you're trying to get them to me, and once they're with me, they've kind of decided, okay, we need to do something. So, and usually after our first conversation, they realize the value in it.
When you have your clients that start this process, one of the important and challenging things to think about is who are you've got like your list of people to whom you're going to
Hmm.
essentially entrust your financial affairs in the event of your incapacity or death. And
Yeah.
if you have kids, they're going to sort of help in many ways, like literally and figuratively shepherd your children into adulthood.
Hmm.
And that is a weighty responsibility. So as
Yeah.
you counsel your clients for fiduciaries, trustees, executors, the other various offices of the estate plan,
Hmm.
what kinds of input are you giving to help select the right people?
That is a really good question, and I deal with this every day. Um, I encourage them to select the person who is a really good communicator because I find when you can have someone who's doing this role and doing this job and they're doing everything right, but if they're not communicating to the beneficiaries, the other beneficiaries get nervous, and that's when problems start coming up. So a good communicator, even if it's, hey, every Friday I'm sending an email out to say what's happened this week, and even if nothing's happened this week, sending an email out saying nothing's happened this week, just communicate is really, really important to try to keep the anxiety down of the beneficiaries. And then obviously you want someone who's responsible. Someone who pays their own bills on time is a good choice. Someone who doesn't, or maybe they're delayed or they're not great with money and even spreadsheets. Someone who's a good spreadsheet person is a great fiduciary. Um, you don't want to choose someone who doesn't kind of have their own life organized, if you will. And then you really want someone who takes action. And what I mean by that is I find the most expensive administrations to settle an estate when someone dies is if you have a person in charge, a fiduciary who delays and doesn't act, doesn't get things to us in a timely manner. They're just super slow. It really drives the cost up in the estate, and then it also causes problems with the beneficiaries. So I would say those three categories are probably my highest. And then I guess the fourth would be talk to the person that you're thinking about putting in this role and make sure that they are okay serving in it because just because you put them in your document, it's merely a nomination. They don't have to accept the nomination. So you want to make sure that who you're appointing knows that they're being nominated and is willing to serve in that role.
Can you talk about, at a high level, the handful of roles that are most typical and important in estate administration?
Yeah. So when I use the word fiduciary, it really means someone who's in charge of certain aspects of your estate. And it could be during your lifetime too, when we talk about an estate. So you appoint someone as a healthcare representative who is going to make those healthcare decisions for you when you cannot make them for yourself. Super important. And then we have what's called a personal representative, which A lot of people are familiar with the term executor. It's the same thing. It's just what Oregon and Washington calls their executors as personal representatives. Personal representatives and trustees are pretty much the same duties and responsibilities. It's just different names for different documents. So a trustee is a fiduciary for a trust. A personal representative is a fiduciary over wills. And so those are the most common. And then, of course, power of attorney. You name someone. This is during your lifetime to be able to make legal decisions for you when you can't make them for yourself.
One of the other difficult things is, especially in a family context where there's qualified children who are adults who can participate, parents don't want to, you know, they don't want to communicate inadvertently a favorite or
Yeah.
something. So they agonize which kid should be which role. How do you coach your clients through that?
Well, I often see that clients will want to name their eldest child only because they're the eldest, not because they're the one who would probably do the best job. And they kind of have this hierarchy of kids based on, you know, when they were born. Um, I do talk to them through that to see, well, okay, is the eldest a good communicator? Are they going to take action? Are they responsible? What's the relationship with the person you're appointing to all the other beneficiaries? Are they on good terms? Is there issues? So we want to find those things out. But the biggest mistake I see is when they appoint someone just because of their birth order, and they feel like they should. And I talk to them about the dangers of doing that. And that's basically what delays are the most expensive thing in an administration is delay. And, someone who's not a good communicator, that is very hard and could cause some challenging situations with the beneficiaries. The other way I like to coach them through it is most often families, they say they want their families to carry on to still continue to be a good, healthy, loving family when they're gone. And putting someone in a role who isn't qualified to be in that role will I would be almost most definitely going to break up the family. I see it all too often, and it's really sad. So, those situations, I try to coach them through, do we really want to do that? Um, and a lot of people are nervous, and I say, well, you know, you have to have the hard conversation. Talk to your family, tell them why. Frankly, I have been in this and been doing this for so long. I would not, and I mean, I will do it for my family, but it's not the role I ever want to be in. It's a challenging role. You are doing all the work. Yes, you can enlist some help, but you're doing all the work. You're responsible for all the taxes. You're responsible for communicating to all the beneficiaries. You're essentially working for everybody else. It is not a fun role. And so, a lot of times having those conversations, families will say, oh, well, if they realize the burden it's going to be, maybe they don't want to serve in that role. And that's absolutely true.
Heavy is the head that wears the crown, as they say.
Yes, exactly. Exactly.
When you're nominating family members for these roles, it does introduce some power dynamics in some cases that can be fraught, shall we say.
Yeah.
So, for example, you've got a trust, you've got trustees that
Hmm.
administer the trust, and you've got beneficiaries who have access to the capital in the trust with some
Hmm.
guardrails.
Hmm.
All of a sudden, you've got someone holding the purse strings and saying yes or no in terms of applying the terms of the trust to the beneficiaries. Imagine it's like your Uncle Joe, who, you don't like, you have a bad relationship with, and you're waiting for disbursements and there's drama. So, how do you think about in that case where there are power dynamics as it relates to disbursement, trustee, beneficiary, or similar? Um, do we consider non family members, and what does that process look like?
You can consider non-family members. You can consider a neutral third party. A lot of times it's a professional fiduciary. There are lots of trust companies or professional fiduciaries out there who will step into that role. And what's really great about that, especially if you have dynamics in the family that it's already contentious, or maybe you're concerned it could be and things are great now and you want to keep the status quo, having a professional trustee can be a really good option. And when I say trustee, it could be a personal representative, power of attorney, whatnot. Um, but it's a great option because they're a neutral third party. They're the ones who are making those decisions based on the terms of the trust. That's just a side note. A misconception is I have trustees come in and say things to me like, oh, well, they really wanted $10,000 to go to these grandchildren. And if it's not written in the document, we can't do it. So the trustee and the personal representative have to follow the terms of the documents. But there's still a little bit of leeway in there about when distributions are made, how they're made, and what form they're made, whatnot. So there are still some decision-making responsibilities for the trustee, and a professional trustee in those kind of contentious or potentially contentious family dynamics is a really good alternative.
How much does that cost? And are there different levels of complexity or levels of estate size at which it makes sense to switch from Uncle Joe to a more corporate type of approach?
Well, the cost depends. Each fiduciary and trust company have their own, or professional fiduciary have their own kind of fee schedule. But usually it is one of two options, or maybe kind of a hybrid option, where it's based on the percentage, an annual percentage of the assets. I would say usually it's between a 0.5% to maybe up to 2%. Or it's based on hourly work. So that is really, it depends on which professional you tend to go with. Um, I, especially when I have clients that are working and they have an established relationship with a financial advisor, I really like them to go, if they're considering a professional fiduciary, to go to someone who doesn't step into the shoes of a financial advisor. They actually, usually, they're just doing the work of administering the trust when someone dies. And then also, okay, now we're putting assets or continuing on in trust for maybe a surviving spouse or a minor beneficiary, and they're kind of managing it for them. But if they have an established fiduciary, you really want to make sure you choose a professional that is going to maintain that relationship after you're gone. For me, when I have clients with financial advisors, they are so helpful when a person dies in the whole process. And they usually know a lot about the family and family dynamics. So there's just a lot of different types of considerations on who you go with. The other thing, and interrupt me if I'm talking
No, you're
too
doing
much,
great.
but it's okay. The other thing that I found is some of the really big trust companies, you want to make sure before you put them in your documents again that they would be willing to serve in that capacity, but also they're willing to do the whole job. And what I mean is when a person passes away, there are certain things that have to be done. Yes, a lot of times the money is being taken and putting in other trusts for family members, that'll be ongoing until they reach a certain age. But before that time, we have to probably sell a house or maybe a couple houses. We have to file the last final personal income tax returns, things like that. And what I found with some trust companies is they will not do that. They will only serve when all of the administration's been done and the money is now put aside for someone else until they reach, their age of majority or whatever it is. So you definitely want to make sure that they will do the full job before you choose one. Um, You had another question in there. I don't know if I remember it.
Here's a question. What are
Yes.
some other common pitfalls you see or challenges that people maybe don't handle properly as they're thinking about how to construct their estate plan?
Yeah. The revocable trust is a really great estate planning tool. You can avoid probate, which is the court supervised administration. And especially when you have people who rely on you as financially, you're allowing the trustee to step in and they might be able to make certain distributions out during the administration, where if you go through the courts, it's much harder to do that. So with when it comes to trust, the funding of the trust is so important. And that's something that I think is the biggest pitfall with clients is that they will put all their documents together and we may even get their house into their trust and fund it. So just for those out there who don't know what funding is, basically a trust becomes the owner of the property. The trustee oversees it. And usually the person who creates the trust is also the trustee and they're putting their own assets inside of it. And it's just a way to avoid the court process. And there's other reasons to do it too, but that's the big reason. If you don't fund it and you don't move the assets under that trust umbrella, well, then when you pass, they're outside the trust. And we may have to go through a court process to get it into the trust after you're gone. And I would say that's probably the biggest thing. And a lot of people will do a really good job at funding their trust once they put it in place. But then as time moves on, they've sold their house, they bought a new house, and they didn't keep it under that trust umbrella. And we don't find these things out until after they've passed. And now we're going through some sort of court process. That's a big one. I'd say the
Do
other
you
one
find
is,
that do you find
yeah.
that financial advisors are generally helpful in implementing a thoughtfully constructed financial or estate plan? Because I know that for what the work that we do, like it's very important to like asset titling. It's one of those things. It's
Yes.
like a landmine. It's not a big deal until you step on it, and then holy cow, that
Yep.
was very painful. And
Yes.
do you have you had any cases where maybe there was an advisor involved and they were asleep at the wheel, or do you think that people who come in with advisors are typically pretty well served to implement thoroughly?
When a person has an advisor, I think they are more successful of implementing the trust properly than someone who doesn't. Yeah, 100%. And part of what we do is we actually contact the financial advisor to give them what they need to make sure the assets get under that trust. So they're extremely helpful in that. And then also with beneficiary designations for retirement accounts and things like that. I don't I think it's very rare for me to encounter a situation where a person has a financial advisor and they didn't have those beneficiaries in place. So, super helpful.
I know one of the things that we do every year or two is literally look at every account for every client and every name for every beneficiary and say, is are any of these like your ex-spouse, for example, or some other
Yes,
person that if you died and they got the 750 grand in that account, you would be very sad about it. We definitely need to update
exactly.
that post haste.
Yep,
So,
exactly. And it's also very helpful because I'm always thinking about the alternatives as well, the contingencies of the contingencies.
yep.
And so, working with a financial advisor, we make sure that if the children are contingent, their children would step into their shoes if something happens to, a child. So it's, yeah, very helpful. I really uh, encourage people to work with advisors. It just makes everything so much easier. Not only during your life, but when you're gone. And that's one of the biggest, when I ask people, what really brought you here today? They usually say, I just want to make it as easy as possible on those I leave behind.
Yeah.
Yeah.
Tell me about cases where you've worked with illiquid assets, perhaps something like the family property or a business that's closely held, or, I got four kids and I've only got you know, one big illiquid thing that I want to try to help either migrate to the next generation or liquidate in an orderly way or have some kind of plan? What kinds of questions are you
Yeah.
asking in that context?
Well, if with a business, we're asking who's involved in the business. I'm looking to see do they have their business paperwork in order because a lot of times they don't. They just registered with the Secretary of State and they don't have their, bylaws or operating agreements or whatnot in order. So those are the big questions. And we look and see, do you have a strategy or do you have a plan in place when you are gone? Are children involved? Is your spouse involved? And we're just looking at all of those um, scenarios to make a plan from there. But I would say the biggest is making sure their company is actually in some sort of structured, like an S corp or an LLC, and they have the documents because those bylaws or operating agreements will tell us what can happen at death, who can own the asset and things like that. So we definitely have to look at that in conjunction with their estate plan and what they're doing. And sometimes, if there is children in the business, we might implement a gifting strategy to where they're gifting sets of shares of stock in the business or membership units if it's an LLC over time. And you can still structure that in a way to where the client still has control, but maybe they're giving away some of their business, which is good in the sense that they're removing it from their estate. We haven't talked about estate taxes, but they're removing it for estate taxes. They can maintain control. One thing that people don't realize is that when you have a business and at your death, you actually have to get it valued. So that is something to plan for because those can be business valuations, depending on the business, can be expensive. And so we want to make sure that they understand it has to be valued. And if children or other family members are going to be inheriting this, who is at who's active in the business and who isn't, because you can structure it in a way to where maybe the inactive child is still a member, but they are just basically receiving, their dividend. But the child who is active in the business, they have control over making decisions. They have like a different role, but they actually all come out equal when it comes to the estate, but you can put people in different roles depending on their activity. If that makes sense.
Yes. Uh, there's a lot of other permutations, obviously, of complexities. One that I want to think with you about is
Yeah.
blended families and special
Mm.
needs. So, second marriages, both spouses come with kids from a prior marriage. That creates its own complexity, and the ways that things can go weird if you
Yeah.
don't address them
Yeah.
are actually quite interesting to think about and kind of terrifying if you're in that situation. Like,
Yes.
oh my gosh, all my stuff that I spent my life building could actually go to my stepkids who I don't even know that are
Right.
attached to the spouse that I just got married to. More
Yeah.
like, recently there's not that relational continuity with your stepchildren at that point. So, what types of questions are you helping your clients think through in those circumstances?
Well, I'm asking them what their priorities are, right? So a lot of times with second marriages, what I hear is they want to make sure their spouse is cared for and provided for, but they want to guarantee that their assets will ultimately benefit their own children. So if that is their priority, which I would say 95% of the time it is, um, then we can structure their estate plan for that. And we can make sure that, okay, if one spouse dies, the assets can be held in trust for the other spouse. The other spouse can use it for particular reasons. We set that out. Usually it's, to maintain their quality of life. And then when that's the second spouse dies, it ultimately says it goes out to the first spouse's children, if you're following me. But it's just a way to make sure that the assets will go out to your own children. Or it could be, I have nieces, I have clients who don't have children and they have nieces and nephews and they want to make sure it goes out to their side of the family. So there's things you can do in that regard. I will say what I don't recommend, and I see this happen a lot when clients first come into me in blended family scenarios, is they say, well, let's just treat everyone the same and let's give everything to the surviving spouse, and surviving spouse, when they die, it's just going to go out to all of our children equally. That could happen, sure. But when you set it up in that way, you are still giving the surviving spouse the ability to remove or cut out certain people from the actual inheritance. You're also giving the surviving spouse the ability to remarry and give their inheritance to their new spouse. So there's I see, which I mean, I see the optimism, right? When clients come in and they're like, oh, yeah, they're going to do the right thing. Oh, yeah, no, we trust each other. Great. But I have seen it go the other way too many times. And the
Mhm.
other thing to think about, and I see this a lot too, unfortunately, is when people age, they become more vulnerable. And it's easier for them to be persuaded to change something in their documents. And so if you want to prevent, you may trust them now, and if you passed away today, it would go just as you thought. But when people age, things just change. And if you want to protect it from a new spouse to make sure it goes to the beneficiaries you want, the best thing to do is to put it into a trust. Um, for the surviving spouse, and it's called an irrevocable trust. Um, the other the other thing that I would say is I have some clients that say, well, I really want to make sure my children get something at my death. And then we look at the assets. We look and see, are there assets that make sense to go directly out to the children, and the rest maybe go in trust for the spouse. Um, if there's not, is insurance a viable way to make that happen? Do we get insurance so the insurance proceeds can go out to children, but all the other property goes into a trust for the spouse? So there's lots of different things that you could do with blended family scenarios.
As I think about all the different sort of permutations of how your life and family can look, and I think about the sort of varying degrees of how important is it that you sit down with an attorney and thoughtfully consider how your estate should be administered. The like second marriage, 40s or 50s something with two or three kids each, who are established professionals, have a lot at stake. They're sort of, in my mind, I'm curious to compare notes with you on this, Tammy. They're kind of like at the top of the pyramid of this is the most important for you. There's the most ways for it to go wrong. And you really, if you haven't already done this work of estate creation, of trust formation, you need to do that right away.
100%. Let me tell you of a situation that I unfortunately had to witness as an attorney. Um, we had a blended family scenario where the person who died, he basically had his kids from his prior marriage, his wife that he'd been with for several years, a long time, together. And he said, okay, this is what I want to happen. And he explained it all to them. He even had like handwritten notes, but he didn't actually put anything in place. So when he died, there was a house that he owned, that his wife lived in for like 20 some years. They lived together in this house. And under the law, because he had nothing in place, his kids were entitled to two-thirds of his estate. So essentially, he thought everyone was going to get along and be great, but the kids turned on a dime, had to kick her out so they could sell the house because they wanted their two-thirds, and it's not what he wanted. It was a terrible situation. It was a terrible, terrible situation, and they were, like in their 50s. And I mean, that's the worst of it, or some of the worst of it that I've seen, but not having something in place and telling people this is what I want doesn't usually carry out how you think it will.
Yeah, that's a good reminder of occasionally I talk to people and they say, "Oh, I don't have a will." To
Mm.
which you, of course, would say, "Oh, yes, you do. It's called your state intestacy rules. And if you die without one,
Exactly.
then the state's going to give you one." And it's precisely what you just described. There's a formula. Are you
Yep.
married? Yes or no? Do you have kids? Yes or no? Do you have and there's just this whole algorithm. And then you
Yep.
get weird stuff like it goes on a
Yeah.
per capita basis, 1/3 to spouse, 1/3 to child one, 1/3 to child two.
Yep.
And all of a sudden your spouse, your widow, is like trying to find
Like,
somewhere to
what the
live.
heck? Yeah. And the widow actually, in this scenario, she helped raise the kids. And I would say, out of anything, yes, it was terrible. She had to move from her house, but she was just distraught because she like loved these children and couldn't believe this was happening. It was terrible. So in terms of like wanting to keep the family intact, that definitely um, did not happen, unfortunately, in that scenario.
Yeah, that's so grieving. And this is the best appeal I could make to anybody who's listening. Like, if you have harmonious relationships with your kids, and if your kids have harmonious relationships with each other, and you care about preserving that,
Yes.
if there's any like emotional appeal that could possibly get you there, if you want your kids to be friends after you're gone, then a thoughtfully constructed estate plan that is concrete, that is communicated, that is documented, that is
Yes.
notarized, and your advisor has a copy, the prospective executor has a copy. Like you,
Yes.
people know what to expect. You mentioned, Tammy, communication, the role of the
Yes.
executor. Like this is also important for whoever's building the estate, making sure that expectations are set. And by the way, if you're gonna like give it all to charity when you die, like
Mhm.
tell your kids that that's gonna happen too, because they might be making
Yes.
some life decisions contingent on some expectation. And it's obviously, if it's your money and you want to do with it what you want to, awesome. But if they were waiting for you to kick the bucket so they could finally pay off their mortgage and retire early, let Junior know that he needs to actually keep on heading back to the salt mines for a little longer, because that's not what's gonna happen.
100%. I often say, definitely when you put your plan in place, communicate with your family. That's the best thing you can do. Um, Communication is key. I know that sounds corny, but it's so true. And just not even a lot of people worry, oh, well, I have all these assets and I'm worried that I don't want to tell them all the assets are. Well, here's the thing. You don't necessarily need to tell them that, but you do need to tell them how things are going to go. You don't have to get particular on the amounts, but you need to tell them how things are going to go. And then also, if you're not going to tell them all the assets you own, just make sure there's a spot that you have everything organized so that they can find out once you're gone, because they're going to need to do that for to settle the estate.
Yeah. And if you have a bunch of Bitcoin, if you have bars of gold buried in the backyard, if you
Yes.
have other, more like avant garde assets that perhaps aren't going to be reflected on a brokerage statement, something I like to do with my clients, I call it the estate plan supplement. It's like the actual stuff that you need to know
Hmm.
explained in vernacular.
Hmm.
Like, who do you call? You know, attorney's number, accountant's number. Here's where the brokerage accounts are. Here's the credit cards. And here's the code to the safe. Here's how you
Yes.
unlock the iPhone. Here's the little things, that thing that is
Yes.
buried in the backyard or whatever.
Yep.
That is takes you, 30 minutes, and will save. It might preserve relationships of your family who survive you. So it's literally
Preserve
that important.
relationships. Yeah, it'll keep costs down when it's
Yeah.
time to administer the estate. I mean, it'll make lives easier of those you leave behind, which is people's primary motivation.
Well, Tammy, thank you very much for joining us. I'm excited for next week's episode where we're going to talk about estate taxes and the hidden cost of dying. So if you thought today was depressing, just wait. It's going to get even worse. Thank you for joining us today on the show.
My pleasure.
If you liked what you heard this week, head on over to apmsuccess.com, where you can find more content and free resources to help you build a successful career in anesthesia and pain management. If you wanted to leave a review in iTunes, I'd also really appreciate it. Thanks for using some of your valuable time to join me today on APM Success.